5 seconds to go. Start. We now come to the regulations that can be framed relating to private unaided professional institutions. It would be unfair to apply the same rules and regulations regulating admission to both aided and unaided professional institutions. It must be borne in mind that unaided professional institutions are entitled to autonomy in their administration, while at the same time they do not forego or discard the principle of merit. It would therefore be permissible for the university or the government at the time of granting recognition to require a private unaided institution to provide for merit based selection while at the same time giving the management sufficient discretion in admitting students. This can be done through various methods. For instance, a certain percentage of the seats can be reserved for admission by the management out of those students who have passed the common entrance test held by itself or by the state or university and have applied to the college concerned for admission, while the rest of the seats may be filled up on the basis of counseling by the state agency. This will incidentally take care of poorer and backward sections of the society. The prescription of percentage for this purpose has to be done by the government according to the local needs, and different percentages can be fixed for minority unaided and non-minority unaided and professional colleges. The same principles may be applied to other non-professional but unaided educational institutions, that is graduation and post-graduation non-professional colleges or institutes. There is no controversy relating to provisions of the Act and rules where procedure for admission to professional colleges is prescribed. The only dispute that arises for our consideration is validity of Rule 12, which was introduced on 19th June 2019. The object of Rule 12.8a is to ensure that all admissions to medical institutions are based on merit and to bar students of lesser merit from getting admission to better colleges. The notice issued by the Director General of Health Services, Ministry of Health and Family Welfare, Government of India has been referred to by the High Court in its order dated 24th April 2019. The said letter highlights the active participation of a group of students who were blocking all India quota seats in second round of counseling deliberately for financial gratification without intention to join the medical college for doing medical degree. During the said period, in the letter, nearly 1000 identified students did not join after first round. They were being monitored to find out whether they were taking admission at least in second round. DGHS proposed severe penal action against those indulging in such activities. Having been informed of this menace, this court passed an order barring students who take admission in all India quota seats from being allowed to vacate seats after second round of counseling. All vacant seats after last round of counseling were directed to be filled up from a list that is forwarded to the institutions in the ratio of 10 times to the number of vacancies to ensure that all stray vacancies are filled. The contention of the appellants is that being asked to keep seats unfilled amounts to an unreasonable restriction on their right to carry on their occupation guaranteed under Article 19(1)(g) of the Constitution of India. Even assuming the object of the rule is to ensure that lesser meritorious candidates do not get admission to better colleges, the measure adopted by the government in keeping seats vacant is disproportionate. This court in state of Tamil Nadu versus P. Krishnamurthy and others held that a subordinate legislation can be challenged on the following grounds: lack of legislative competence to make the subordinate legislation, violation of fundamental rights guaranteed under the Constitution of India, violation of any provision of the Constitution of India, failure to conform to the statute under which it is made or exceeding the limits of authority conferred by the Enabling Act, repugnancy to the laws of the land, that is, any enactment, manifest arbitrariness or unreasonableness. It is relevant to examine whether a subordinate legislation can be declared as unconstitutional on the principle of proportionality. This court in Kerala State Beverages Corporation Limited versus P.P. Suresh held the challenge to the order dated 7th August 2004 by which the respondents were deprived of an opportunity of being considered for employment is on the ground of violation of Articles 14, 19 and 21 of the Constitution of India. Lord Diplock in Council of Civil Services Unions versus Minister for the Civil Service held that the interference with an administrative action could be on the grounds of illegality, irrationality, and procedural impropriety. He was of the opinion that proportionality could be an additional ground of review in the future. Interference with an administrative decision by applying the Venesbury principles is restricted. Stop.